My name is Liz Gray. I'm a consultant to Oakland Planning and Development on the neighborhood quality. And I'm going to be running the show tonight. We're talking about renting in Oakland, which is sometimes a chess match and sometimes it's a bad game of baccarat. Okay, so we have a couple of people with us tonight that are going to be able to answer some questions for you. We have Trisha Mark, and I'm going to say your last name wrong.
Marjotti
from the University of Pittsburgh Office of Off-Campus Housing, and there's Adam. And your last name?
Debo.
Adam Debo from Neighborhood Legal Services. Okay, we're going to start off with Trisha. And do you have the slides, Sam? Where's your office located, Trisha?
You know, I don't have an office right now because we've created a new department under Student Affairs, and we're working with the Office of Engagement and Community Affairs. They're trying to find us a place, but at the current time, I am in Panther Central in the Towers lobby, in the Litchfield Towers lobby. That's where you come and get your ID and everything. And when I get a permanent office, I will let everybody know so you know how to reach me. Okay, our mission statement, we're committed to ensuring students are knowledgeable writers. Our mission is to provide students with information to the tools needed to successfully reside off campus. Our services can help students find housing and resources safely to live off campus and support. You'll need to be a responsible neighbor, from renter's guides, apartment listings to useful tips. And we're here for student services. Next slide, please. Okay, and this is basically what we do. We're educating and supporting students to live and thrive in off-campus living. We accomplish this by helping students make informed choices with housing and roommates, encouraging students to become knowledgeable and responsible tenants, assisting students in gaining the proficiency to solve problems when landlords and roommate difficulties arise, becoming a good neighbor and being active in the community, developing student awareness of community values and responsibilities, which is a very strong point with me here. We just want to make sure students, when they sign the lease, how they send a rental application, how they view their lease, not to how they review their lease, what to sign, what not to sign, renter's insurance, making sure students are following occupancy permits, no more than 3 unrelated people in a single family dwelling. We thrive to make sure students are reading their lease, and when they sign a lease with a whole bunch of roommates, it's like my roommate's not paying the rent. Well, when you sign a lease, it's usually jointly and severally.
Types of leases and responsibilities.
Yeah, it's things such as rental payments, utilities, lawns, snow removal, trash disposal. As I know with Liz, that's an important issue. How to handle repairs, date start and lease date, move-in reports, move-out reports. And a big thing is when students go away, this was big this year, when students go away for the winter break, keep your heat on. We had so many frozen pipes over the winter this year. Next slide, please. How they terminate the lease, fees that would be under the lease, such as some landlords will charge for carpet cleaning, and students aren't aware of that because they just came through their lease. Next slide, please. These are some other helpful tips, and we'll be glad to share this presentation with you also. Damages, make sure students are doing damages, and if they need to sublease or get out of a lease. Make sure the landlord's required to give notice if it's not an emergency. Next slide, please.
A quick question. If you have 3 people say at least one person has to pay the rent, are they all responsible for the rent?
Yes.
Yes.
Okay.
Okay, this is very important, renter's insurance, because students don't realize that under any circumstances, and it's presented in most of the leases, students are never responsible for any of your personal belongings, even if it's their fault that a pipe bursts or if someone breaks into your apartment. Students don't realize, and we go into detail with students how important it is to have renter's insurance. Okay, next slide, please. And this is our Be a Good Neighbor initiative. We work collaboratively with Office of Engagement and Community Affairs and the picnics and making sure our students are good neighbors, and our new ambassador program that we just kicked off. There's more to come on that, and we're here for our community. And the next slide, please. Okay, this is all my contact information, our website, if you would like to go over that. If anyone ever has any questions, please feel free to reach out to me at any time. And I'm done with my presentation. Any questions?
So Tricia, how do you disseminate this information to students? I know we have workshops and I know there's a webpage, but I'm curious about all the different strategies you have in getting this important information to our students before they actually get off campus.
It's mostly through word of mouth at this point, but us being under student affairs, I'm sure that we're going to have a social media page, and this information is going to get out. Students are able to find us because we get a lot of students coming in where I'll help them read over the lease. If I don't understand the lease, I send them over to the student government board. Everybody knows Panther Central. Everybody knows to come into Panther Central, and they usually know where to guide students. Right before, for undergraduate, our biggest time, which is right now, when they don't get their suite selection, everybody seems to find me.
Has the university ever considered sending out just a general mailer to returning students that are coming back in the fall? You know, that it could be sent with something. Yeah, I'm sure that they're doing other mailings to the university students as the end of the summer comes up. And, you know, or even during the winter, just throw it in with another mailing. This is the kind of information that really needs to be, I think oversold is the best word.
That's a great idea, Liz. As you know, we're starting up a new department under student affairs, and I'll mention that to our supervisors and our boss, and some of the people with office engagement and community affairs are also here, and we work collaboratively with them, and they'll also bring that up also. That's a very good point. Thank you.
If it's easily done, technically, I'd like to see the second to the last slide again.
Okay, go ahead.
They're just putting the chat out. Once we get this one, I'll come back for them.
Or if the presentation can be made available, that would be fine too.
Yeah, please just email it to her. I'm glad to share it.
Thank you. Whoops.
This number is.
Is that the one, Elena?
The
No.
contact
Yeah,
phone.
it had to be the one. I'm sorry, go back.
What was it concerning?
It was concerning the ways they're good neighbors, block parties, workshops, and there were 2 other things I think I missed.
That would be under the Be a Good Neighbor.
Yeah, there they are. Tenant workshop, student guide, and then you said the ambassadors. Okay, that's what I was
Yes.
trying to get. Thank you.
You're welcome.
Okay, there were a couple of hands raised in the chat.
Yeah, there are a couple of questions. Elena asked one about parking. And then we have another one about services and whether or not it's just Pitt students that qualify for services from Trish's office.
Anybody who has a Pitt affiliation can come in.
And all the other universities also have housing programs or off-campus housing programs. CMU, Duquesne, living on the south side, I've worked a lot with the people from Duquesne University because we're Duquesne lives. So, and I know Carlo does and Spring Park does. Yeah, so I think you're pretty well covered for any student attending a university in the city. Now, do you have like a physical booklet or is there a web page that they can go to get all the information?
Yes, it was listed on the last page of my presentation, all the contact information in our webpage. Our webpage is ocl.pitt.edu.
Yes, and we have from Mark regarding the students getting pets. Now, that is a problem, but this is a problem that truly was born out of the pandemic, more so than most years. And a lot of people did get pets, you know, it was company and home and everything. But if the student gets to a point where they cannot deal with the pet, there are several organizations in the city that will gladly let you surrender your animal. Animal Friends is probably the one I would go to, but the Humane Society, you know, so there are options available because sometimes, you know, a pet isn't something that you just feed in the morning and it goes away. That's a big responsibility. It's a living thing. So that's fair enough. Also, when you have a pet and you're living in an urban community, you go out with it and they poop, you clean. Okay, that's just wise old saying. The other thing, you know, we were talking about leases. In all years I've been doing this, and no matter how many times we stress this, students need to be encouraged to read their lease at least twice. Highlighters, everybody owns highlighters. Highlighter. If you have any questions, you can call Trish, or you can call myself, because once you sign that lease, that is a binding legal agreement that you have to stand by. Okay, and it's very important that you're aware of all the details in that lease. I dealt with some students over the holiday break that had a water break in their place, and they had one student that wasn't on the lease, and she had no protection at all. Okay. So that's something that they really need to consider. If they over-occupy, only had 3 people on the lease, a 4th or 5th student, they had no legal stand and they had no protection, but they've been paying rent. And also the 3 people that signed the lease, if the 4th or the 5th person who is not appearing on the lease, they could just walk away and say, bye. And then those 3 people that are legally on the lease will be held responsible for the full amount. So. Okay, moving along here. Does anybody else have any questions for Trish? See another hand up in the chat.
It's just Mark's comment.
Okay, is that Mark?
Yeah.
Okay, we're going to move along now. Adam is here tonight with us. He is from Neighborhood Legal Services, which is a good place to start when you're doing any kind of legal lease, and the lease is legalese. Adam?
Yeah. Absolutely. So hi, everybody. My name is Adam Debo. I am the managing attorney for the housing division at Neighborhood Legal Services. I just put our information in the chat. So that's a link to our website and our intake number, if anybody's interested in our services. So basically, we're a nonprofit civil legal aid firm. What that means is that we are effectively like public defenders for civil cases. You know, you're guaranteed a public defender in a criminal case. In civil cases, you are not, but we step in and provide free legal services to folks who find themselves in civil legal situations. Mainly what I deal with is landlord-tenant cases. I represent tenants in eviction cases, so my days are spent reading leases and preventing evictions and things of that nature. I also went to Pitt for undergrad and law school, graduated in 2019. So I've lived in South Oakland for quite some time. as recently as 2019, and I'm still a renter. So yeah, I didn't bring any slides to have a presentation. I figured I could answer questions if anybody has any, but I'll kind of go over a few of the kind of most important things I think for renting for students, and then also renting generally as well. There was a couple programs last week about student tenants, so I'm going to be basing my remarks today on some of the more common questions that I got last week from a lot of the students. I know this has already gone over a million times, but reading your lease is by far the most important thing that you could possibly do. That's every single time I get a new case, the first thing I do is look at the lease and see what the rights and responsibilities of the tenant is. So, you know, every single thing that is going to pertain to your tenancy is going to be in your lease. Supremely important to read that. A lot of those things that you should be looking out for, first and foremost, is the amount of rent that you're paying and who is actually on your lease. So this was mentioned earlier. Leases have what's called joint and several liability. So each person is responsible for their portion of the rent, but each person can also be responsible for the entire portion of the rent if it is not paid by any of their roommates. So it's really important if you're a student to make sure that you or your co-signer is aware of the amount of rent that is going to be paid, to be aware of who your roommates are, and to make sure that you have kind of properly vetted them when you're moving in with someone, because you don't want to be stuck with having to pay the entire amount of rent by yourself if one or two of your roommates just gets up and goes. And as Liz, yeah.
I was gonna ask, how would you vet somebody before you move in with them? I mean,
it's kind of difficult your first year to do so. But I mean, make sure that you know the person, make sure that you get along with the person, make sure that you are kind of aware of what they'll be like, that you spent enough time with them to really make the determination that yes, that you know, it will be a good idea to live with them. A lot of people, and I know it's difficult, you know, if you start your semester in August, you know, you're probably going to be looking for an apartment around February, March. So that's pretty difficult to do, but you know, I would say do your best to make sure that you're moving in with somebody who is responsible, who's going to be you know, not just a good roommate, but a good tenant as well, because you don't want to get caught up in anything that they might have been involved in.
okay, we had a question here in the chat. Are roommate agreements legally binding?
What do you mean by roommate agreements?
Well, sometimes when you move in with a group of people, it's, well, we've all agreed that we will all share paying for the milk and the bread, but anything other than that, it's your own personal responsibility. We all agree that we're going to pay 1/3 of the cable bill, and, you know, everybody signs a paper with all this kind of stuff on it as an agreement. Can that be enforced?
Yeah, I mean, technically, if you have something that's in writing that everyone has agreed to the terms of, as long as you're 18, I know some people aren't when they get to college, but as long as you're 18, you have everything in writing. It's all, you know, it's all signed by everybody and agreed to. Most of those things can be legally binding. It just depends on what the terms are and if they're actually reasonable, but they technically could be. The problem is your enforcement of those things is going to have to be to, like, later on sue your roommates, which is a laborious process and is going to take time and money, which is why it's better off just to make sure that you're living with somebody who that's not going to be an issue with in the first place.
Even if you win, sometimes you don't get the money.
Yeah, I mean, you could win and then you have a piece of paper saying that you're owed this money and then you have to go and collect it, which is a whole different beast as well. So yeah. But you know, just that goes back towards making sure that you know who you're moving in with, making sure that you understand your responsibilities and the potential liability that could come to you if your roommates don't pay certain bills, if they don't pay their rent, if they don't do, you know, X, Y, and Z. And that goes towards damages as well to the residents. You know, all the tenants are jointly and severally liable for that. And, you know, the remedy for all of these things is that you can sue your roommates. But again, no one really wants to get into that whole process. A couple other things to be aware of when you're looking at your lease, what your lease terms are, as far as like the dates. Most leases, everybody knows, are going to be for a year if you're a student, most likely. But you should always check the terms and see what your lease renewals are like. Some leases renew automatically. Some leases you have to give notice to your landlord if you want them to renew. Some leases renew automatically for a year term. Others are month to month after that, which can put you in a bit of a weird spot. So you want to make sure that you know what kind of and how long of a lease you're signing. You want to know what utilities you're responsible for. Electric, gas, water is usually going to be in the landlord's name, but it's really impossible to know before looking at your lease who's going to be responsible for what. You should also get an idea from your landlord, maybe from the previous tenants and from the utility companies, what your bills might look like. You know, a lot of people are renting in you know, they're coming in and they're going to start living in their place in move-ins, which are going to be in July, August, and your heat bill is going to be fine. It's going to be really low. And then when December, January, February rolls around, your bill might be through the roof. So you can, you know, contact your landlord and ask them, talk to the previous tenants if you can, talk to the utility companies about what that's going to be, because that can be kind of an unforeseen cost that you might not be taking into account when you sign your lease. Couple other things. Yeah.
Someone just asked a question in the chat. Can landlords post vacancies with you?
I think that might have been for, for true.
Oh, gotcha. Sorry. Continue.
One of the things that we've run into over the years, Adam, is I've had students where the landlord has said that they want paid in cash. I even have one that said, we want paid in cash in small denominations.
Yeah, that's a terrible idea always. If your landlord, if you're going to sign a lease and your landlord tells you that they want to get paid in cash, just find a new place to live. If you're paying your rent, you want to be able to prove that you're paying your rent. You want to be able to prove, in the case that maybe there is a fallout between you and your roommates, that you want to be able to prove how much rent you as a singular roommate actually had paid as well. And if you pay in cash, there's no way to do that. Even if your landlord says they're going to give you a receipt, the practice is just, it's just not a good practice. So if your landlord is doing anything like that, or even anything that you just feel is off, right? If it sets off a red flag, hey, I want you to pay in cash. Hey, like we had talked about with the occupancy. Yeah, there's going to be 5 of you living there, but only 3 people have to sign the lease. Yeah, you know, these rooms are kind of makeshift and they're not up to code, but it's fine because you can have 5 people there. Anything like that you feel is a little bit off. You know, I know finding a place is difficult, especially if you want a good location, but you don't want to risk what might come down the road if you're doing something like that. It's just bad practice for you. And, you know, it also enables the landlord to keep doing those things in the future, which is bad. I see a question.
Yeah, I was going to ask, do you have any kind of recourse of when, say, one person in the house signs up for the electric, another person signs up for the gas, another person signs up for the internet? So they're like, each of us are going to have a bill, but the guy that has the internet decides that, oh, I'm not going to pay that, and they just wander off. What kind of, can you get utilities signed up under 3 names, multiple names, or does it have to be in a singular person? If your roommates go bugger off on you, do you have any recourse against them on utilities?
Yeah, so I'll answer that one first, and then I'll answer the question in the chat. So for utilities, it is technically possible to have utilities in multiple residents' names, although I'm not exactly sure. I mean, I've always had the situation where when I've had roommates, one of us has taken a singular bill. I haven't had any problems with that, but it is possible to get it in multiple persons' names, or just to have the account for, you know, tenants of this residence, and then have the names on the actual account, which is possible. I would say contact the utility company. I'm not super well versed in that necessarily, but the utility companies are usually willing to work for you, especially if it's been a situation like that where they see that it was in one person's name, that person has stopped paying, and that's going to have a detrimental kind of consequence on the other tenants of the property. You can likely get it established in your own name if it stopped being paid, and you want to make sure that, you know, especially your utilities, internet. Yeah, I mean, that's going to be an inconvenience. And if it's in someone else's name and they stop paying, that's going to be bad for them. It's going to be an inconvenience for you, but not the worst thing. Electric and gas going to be problematic because you might lose service. Water is usually going to be in your landlord's name. If it's not in your landlord's name, if one of you as a tenant is responsible for water, that has the utmost priority. Like that needs to get paid no matter what. Because if your water does not get paid, the water authority can actually levy that against your landlord's property, which is a huge problem for tenants. And that is going to be all kinds of trouble if that's the case. So once again, I think the best plan of action is like to make sure that you know who your roommates are. But working with the utility companies, they'll usually be able to address that situation. In the chat, if a group of 3 students stops paying rent, what recourse does the landlord have? The landlord will evict you. The landlord will file a landlord tenant case against you because you stop paying rent, and they will try to evict you. At the very least, they'll get a judgment against you. And if you don't pay that judgment, you can get evicted, which is a terrible outcome for you because every landlord that you apply with in the future does a check to see if there's been any landlord tenant actions filed against you. And if you have one that's been filed against you, that's an automatic no for many, many landlords. So you really don't want to let it get to that point. So, you know, if there's a group of multiple students and they just stop paying generally, your landlord is probably going to take legal action against you. They might give you notice, they might not give you notice. Another good reason to check your lease to see if your landlord has to give you some type of notice before taking legal action. If you live in a private residence, there's a 99% chance that you've waived your right to notice. But something to check for in your lease. But your landlord does have the right to take legal action against you. If you've breached any terms of your lease, doesn't matter what it is, and paying your rent timely is one of those terms of your lease.
Okay. Would a tenant have, say there's a problem with the apartment and the landlord is not addressing it, like there's no heat and it's 5 degrees out and they're like, oh, well, it's busy, it's the weekend, we won't be able to get anybody there until Monday. And if they don't come on Monday and when you complain to the city, file like a 311 ticket. And then the landlord gets upset because you've involved the city, even though they're the ones that have broken the rules. You know, I always have students ask me, but if I do that, we're gonna get thrown out. You know,
Yeah.
I'm like, right to complain, you're paying.
Yeah, so this is a difficult issue. So I'll talk about generally like habitability issues first, and then I'll get into your specific question, which is about retaliation.
Yeah.
So habitability in the first place is basically any sort of issue with your residence that might make it less livable than it should be. This is basically in every lease, no matter what. Even if it's not written in your lease, there's something called the implied warranty of habitability, which means that it can't be waived. It's in every landlord-tenant relationship, no matter what, and your landlord has to abide by it. It's state law. They can't get rid of it. And what that says basically is that every landlord has the obligation to give a tenant a safe, a habitable, sanitary residence to live in. Now this has to go towards things that are actually like issues with habitability, not like aesthetics. You know, you're like, I don't like the color of the walls. I don't like the, the bathroom's super ugly. Maybe there's some paint peeling here or there. That's like not due to anything structural, not going to necessarily be a habitability issue. Things like Liz said, the heat being out, constant leaks, faulty electric, any infestation issues, whether you have, roaches, mice, whatever it might be, anything like that. Those are all going to be habitability issues. And I'll talk about that, Mark, in a second here as well. And I'll also get to the other question about how to check if a roommate has a legal action taken against them. So if there is a habitability issue in your residence, the first step is to notify your landlord of that issue. And what you want to do is notify them in writing. So a lot of people have, there's a portal that you can go on to submit a maintenance request, or maybe you have your landlord's number or something along those lines. I always say it's best you have to have it in writing for sure. You want to be able to prove that. And you want to be able to give your landlord notice in writing. I would recommend doing it in more than one way. So if you can put a portal request in, definitely do that so they get it through the portal, but also send an email or a text. A written letter is like the most ideal way to go about it. Two methods of written communication, probably best. If you send your landlord an email about the issue and they say, hey, give me a call and we'll talk about it, make sure that you memorialize anything in writing. So written notice is the first step. Once you give your landlord written notice about a habitability issue in your residence, they have a reasonable amount of time to fix the issue. And what reasonable is dependent upon what the issue is and other contextual factors. So if it's the middle of August and your heat goes out, you know, your gas heat stops working, a reasonable amount of time to fix that might be a few weeks. You're probably not going to be using your heat in the middle of the summer. If it's, you know, when we had that cold snap right around the new year and it was 4 degrees outside and your heat goes out, a reasonable time to fix that is going to be like within 24 hours. So your landlord has a reasonable amount of time to fix these things, and the severity of the issue, the context surrounding it, is going to be the key there. If your landlord doesn't do that, you definitely want to give them more written notice about that. And then you can potentially go to this city, to code enforcement and things like that, to complain to them about your landlord. And they will give a formal request to your landlord to fix those issues. A couple remedies if your landlord doesn't fix the issues, and there's a couple questions in the chat about this, would be to withhold a portion of your rent is an option. It's not one that I recommend. It would be to repair the issue yourself, or like by hiring a person to fix the issue, and then withholding that amount that you paid for that service from your rent. Those are basically the two most common remedies for that situation. What I would recommend generally, and I'll kind of get into the questions in the chat here. Mark says, correct me if I'm wrong, you can't just stop paying rent. You need to get PLI or the health department to cite landlords for violations to set up escrow. Not true. Don't have to do that. In order to at least have some sort of legal claim to withhold your rent rightly for habitability, you just have to give your landlord written notice that there's a habitability issue, and your landlord has to not make those repairs within a reasonable amount of time. The person who decides as to whether or not your landlord did actually comply is the judge. So even if PLI or the health department cites your landlord, a violation of a code is not per se breach of the implied warranty of habitability. You know, they might get the health department to come out, and the health department might say, yeah, you have a loose railing on your front step. Technically, that's a code violation. You might just use the back door every day, so it doesn't really matter for you. If you withheld your rent in that situation, you would almost for sure lose that case, and that would be very bad for you. So you don't have to actually get PLI or the health department to cite the landlord to withhold your rent. But you are right that you should set up escrow if you're going to do that. This is something that I would recommend to not really do at any point, unless the situation is very severe. Because specifically, like Liz had said before, your landlord is likely to retaliate against you. But if you do choose to withhold your rent, there's a couple of things that you can do to be safe about it. You do want to set it up into an escrow account, which just means to kind of take the money that you would have paid for your rent, put it into a separate account. You can do that with your bank. Put it into a separate account where you're setting it aside. So the court, so your landlord, so everybody knows, hey, I have the money. I'm just not going to pay it while these habitability issues are out there. And you should only withhold the amount of rent that is proportional to the amount of loss of use of your residence due to the habitability issue. So if you have a plumbing issue and you have 2 bathrooms and one of your bathrooms no longer works, but you can use the other one and everything else in your house works fine, you know, you might only be withholding you know, 1/5 of your rent, something along those lines. It should just be proportional to the amount of loss of use of the residence that you have. Many people will withhold all their rent, which is almost never a proper remedy unless the place is actually just unlivable, which can be the case if your heat is off, if your electric is off, if something along those lines is happening. That's how you would properly escrow that. It is an option. It's not one that I oftentimes recommend. What I would recommend is if you have the capability to do so, to hire somebody to fix the problem, and then to bring that to your landlord and let them know that you would want to be compensated for that issue, which you fixed after their failure to do so. And that if you are not, you would like to withhold rent in that amount the next time that you pay rent. But regardless, you need to give your landlord some notice that you are going to be taking one of these remedies, that you're going to be withholding your rent or repairing the issue yourself and deducting it from your next rental payment. Your landlord should be aware that that's what you're doing. So really an open communication with your landlord, making sure that there's proper notice is always going to be necessary in these cases. So let's just say that this happens. There's a habitability issue. Liz asked about retaliation. Unfortunately, that is allowed in Pennsylvania because if you withhold your rent or if you repair and deduct your rent, technically you didn't pay your rent. And even though you may have been rightful in doing so because there's a habitability issue, your landlord does have the opportunity to take you to court to see if the judge agrees that that was a rightful withholding. And the judge is going to be that fact finder. The judge is going to be the one that makes the determination as to if your withholding was rightful or not. So your landlord does have the right to take you to court to sue you if you withhold your rent, if you repair and deduct anything from your rent. And it's basically up to the judge to determine whether or not you were correct in doing so. It's a general rule. It's really iffy if you're going to want to withhold your rent or to repair and deduct. I would just recommend trying to have an open line of communication with your landlord and to make sure that they know every step of the process, what you're going to do so that they don't get caught off guard and then kind of retaliate against you. Super long-winded explanation. It's kind of a difficult topic. It's probably the most common thing that I see day to day. And it's definitely common in Oakland as well. I mean, I lived in Oakland for like 5 years. There's a lot of places that are pretty slummy, and that's just the reality of it. So something that's unfortunately very common. Just make sure that your landlord knows about what's going on.
Are there any other questions in the chat?
Well, one thing about paying in cash, the landlord, more than likely the landlord try to avoid paying taxes
Yeah.
because of required income. Because
It's
I had to roll rental property. I had a couple tenants who came from a different landlord, moved into my place, and their landlord said, good tenants pay cash. And, you know, they have to get a receipt when they pay cash. I mean, it's, and if your word against their word.
Yeah.
Yeah, I mean, if your landlord asked you to pay cash, just find a new landlord. Don't ever do that. It's just a horrible idea. I don't really care if they say that they're going to give you a receipt. All it takes is for them to not do it one time, or you lose a receipt one time and then you're out of luck. So I would just say, like, that's a huge red flag. It's 2023. If your landlord wants you to pay cash, it's because they're committing tax fraud. And it's just a bad idea for you to do that pretty much every single time.
Okay, now I'm gonna put the shoe on the other foot. Say you rent a place and you decide that you are going to have a party on Friday night and you're gonna charge everybody $5 at the door, 20, whatever it is, okay. And you know, that legally, that can put you in jeopardy for the long term. If you end up with the police there or something, they have no, I'm trying to think the right way to put this. What is a student's legal obligation to the community that they're living in to behave in a reasonable manner?
Yeah, so there's something called the right of quiet enjoyment, which is, it kind of goes both ways, right? So you have the right to quiet enjoyment in your own residence, which means that you have the right to be free of something like a party that might be going on. And if something like that is going on, then your neighbors or whoever you are disturbing is going to inform the authorities. You're going to get a knock at your door from the police, something along those lines. If that becomes an issue, potentially on one occasion, but usually on more than one occasion, if that becomes an issue that you are continually doing things that breach your surrounding neighbors' right to quiet enjoyment, your landlord can take legal action against you for that, right? If they get informed that, hey, the cops have been called to your house 3 weekends in a row because you're throwing ragers, your landlord can try to evict you for that. They absolutely can if you keep doing that. And that is just the act of having the party, right? The act of being too loud, the act of disrupting your neighbor's quiet enjoyment. That is not, if there's any damages, if anything actually illegal happened. In almost every single lease, criminal activity in your residence is a breach of the lease. So if anything like that happens, then there's another grounds potentially for legal action to be taken against you. So I mean, this is basically a respect thing, right? Like you want to be in your own home, especially if you're a student, you're trying to study, you're trying to get your work done. You want to have the right to quiet enjoyment. When you want that to happen, your neighbors are going to expect the same thing as well. And I know that South Oakland is mostly made up of students, but there are people there who are no longer students. There are people there who recently graduated who still live there and are working jobs, things along those lines.
Okay, now I'm going to go back to the other foot again. A lot of times when I talk with students and they're, they think, oh, this is terrible, and we have bed bugs, we have this, we have that, and everything. And I'm like, well, have you complained to your landlord, or what are you going to do? And they're like, unfortunately, a lot of them are quite honestly just afraid to say anything to the landlord because they don't want to get evicted, which is why they have a fear of actually, saying something to the health department. Hi, the building I'm in is infested with rats. They just, it's midterm. I don't want to get evicted from my apartment. It's spring break, whatever. I don't want to get evicted. So.
Yeah. So a few things. Well, real quick, I'll answer Trisha's question in the chat. Is it legal for landlords to stay in a lease no guests? Almost always no. That's not really that's pretty much an unconscionable term to have in a lease. It kind of depends upon a few contextual things, but if you're a student and you're living in a place in South Oakland, that is likely going to be an unenforceable clause in a lease that you're not allowed to have any guests. Now going to your question, Liz, what to do if you have a problem, you're afraid of bringing it up to the landlord because you're afraid that your landlord might take legal action against you. I mean, if it is the case that you have a legitimate issue and you're afraid to raise it to the landlord, there's a couple problems with that. One, if there's a habitability issue that you think your landlord might blame you for any potential damages that arise from that, right? Like a leak that's impacting like the stability of the place, if there's rats that are really causing some damage, chewing on wires, things like that. Even like if your toilet is running and you don't bring that up to your landlord to fix, right? If your water bill is through the roof and you never told your landlord about it, you're going to be responsible for that. If there's damages that are being caused by a leak and you never informed your landlord about it, you might be responsible for that. So it's important for your own kind of, monetary, incentive to make your landlord aware of issues like that. And if your landlord tries to, like I said, they can legally file something against you for complaining, but they also still have the burden of proof to show that you actually breached your lease. If it's clear from what they're doing is wrong and you have to go in front of a judge, the judge is going to understand that, right? If the place is absolutely in horrible condition and you could send photos and you have proof of that, the judge is going to see that. So you complaining against that doesn't mean that your landlord is successfully going to evict you or successfully bring a legal action against you. It just means that they can. So it's always good to report anything like that to your landlord, just so they know and can potentially fix any of the issues that are going on.
So it all really comes, sorry, go ahead.
I was going to answer Mark's question in the chat here. Are any tenant activities worthy of immediate eviction? I guess it depends on what immediate eviction means. Every eviction has to go through the proper landlord-tenant legal procedure. So it has to at least get filed at the magistrate. And then at that point, tenants have appeal rights to bring it up through the Court of Common Pleas. So insofar as like an immediate eviction, like your landlord throwing you out, disposing of your property, changing locks, anything like that, that's against the law. They're not allowed to do that. There is an expedited eviction process for if you are manufacturing drugs in your home, or trafficking drugs within your home. There's certain restrictions about that that are a little bit different. But realistically, what's called a self-help eviction is going to be illegal, right? There's still a legal process that has to take place, some determinations that have to go into it before someone can be evicted. Really, no matter the severity of the incident, realistically. Millie, I think that's a fair point as well. There are definitely long-term residents, which I had touched on before when I talked about the right of quiet enjoyment. There are homeowners, there are long-term renters there. But I think realistically, a large majority of Oakland, especially South Oakland, is going to be student residents. And this was a kind of a town hall for student renters. So not to show disrespect to any of the long-term renters or any of the homeowners. I think something like the right to quiet enjoyment is extremely relevant for folks in that situation as well. And it's important for the student tenants to understand that, there are folks that aren't just going to be spending 12 months in a place and then finding a new one on the other side of the boulevard or something along those lines, that they have people that have been living there for quite some time.
Alan, maybe I can clarify something. There's something we found over the years is that the University of Pittsburgh refers to anything south of 4th as being South Oakland, whereas in reality, the neighborhood by rights is Central Oakland. South Oakland begins on the other side of the boulevard. Okay, so Central Oakland is where the density of student population is, not South Oakland. Sorry, just because I get this all the time with the city police, with everybody.
Yeah, I think that's a fair distinction to make. Maria in the chat said, when does a habitual guest become a tenant? They're not going to become a tenant unless they sign a lease. What they might be is what's called an unauthorized occupant, which is a problem for the actual tenant. So someone can't be a tenant unless they've established a landlord-tenant relationship with the landlord, unless they've signed a lease, and unless they are, they're paying rent to the landlord, something along those lines. If you're living somewhere and you haven't signed a lease there, what you are is an occupant, potentially unauthorized. So if I sign a lease and it's just myself and someone moves in with me and my landlord is not aware of that, that's going to likely almost 100% of the time be a breach of your lease. That's a problem. Same thing with, a habitual guest becoming an unauthorized occupant is effectively, does it feel like this person is living there, right? Like, do they have another address that they stay at? Do they have the things essential for living somewhere at this residence, right? Like, did they bring their whole closet full of clothes over there? Do they have things to stay there for multiple weeks on end? And Mark is right. Some leases do define terms. If someone stays somewhere for more than 2 weeks, more than 14 overnights, then that person can potentially be deemed an unauthorized occupant as opposed to just a guest. So definitely check your lease for that, but it's more of like, does this person feel like an occupant? Are they actually living there?
I have one last question that again has come up in conversation with students. Can a landlord prohibit guns being brought into a house that you're renting? And if you're like 3 students in a house, all of a sudden you find out your roommate decided to pick up a gun and brought it home, but you weren't aware, it just shows up with it. Is there any legal recourse for the tenant, and where does that stand? What's the legal standard?
Yeah, it's an interesting question. I will say generally, it's not one that I have there's not an exact answer to this question. As long as you're doing everything legally, you're probably, as long as you're doing everything legally, insofar as like state laws and city laws, you're allowed to own a gun. Most of your leases won't necessarily state that you can't own one on the premises. Like Devon said here, his lease says that he can't, quote, discharge a firearm on the premises, which is an interesting clause. But I think you'd be pretty hard pressed to find an actually enforceable clause that says that you can't own one. I don't actually think I've ever even seen that in a lease, outside of some interesting like public housing and subsidized leases. But I think that'd be really difficult to argue that you're not allowed to have one on the premises. If it's in your lease, it might not be enforceable. Although it might be. I mean, this is not really an issue that we see frequently, if ever, honestly. And I think would be one that would be pretty hard to enforce against a tenant as long as they're following all the laws properly. If you're breaking the law, I mean, I know the city of Pittsburgh has a law against owning a handgun. There's a couple other like local and then state laws about gun ownership. I would say that, you need to be following those if you're going to own one. I know Pitt probably has a violation. Pitt probably has a clause against this in their student housing, which is, that's kind of separate from talking about private rentals. But it'd be a pretty difficult thing to litigate, I would assume. Not something that I'm very well versed in. If you found out your roommate had one, if your roommate brought one home, what could you do? Probably something outside of the law that you would have to do to kind of talk about that, to understand what's going on with your roommate, talk to your roommate about that. We're getting more into like a social kind of factors into what's going on there, as opposed to something that's strictly legal. Definitely a difficult subject. Mariah, is no overnight guests an enforceable clause? Maybe. Kind of a tough situation there as well, right? It'd be pretty difficult to just say that you having an overnight guest one time during the entirety of your lease would be something that would technically be a breach of your lease, but it does depend on the situation. A lot of these things are kind of up for debate. Is this or is this not like a material breach of your lease? So that would be difficult. Yeah, things like that, Devon, are more common. His lease says that you can only have 4 overnights within a certain time frame. Things like that are common, where they say you can only have this many overnights within this time frame, as before that person can be deemed as an unauthorized occupant. Those are pretty common. I think those are still even debatable as to whether or not that would be specifically a breach of your lease, but those are much more common and much more reputable than something that would just say no overnight guests, or like no guests at all is almost never going to be enforceable. Mark said some laws that don't apply to small rentals, 3 to 4 units, especially where landlord lives in my building, which is his case. Do you think a gun ban would hold in that case? So what you're referring to most likely is the Fair Housing Act, and then even more specifically than that, something in Pennsylvania called the Human Relations Act, which has more so to deal with discrimination as opposed to something like a gun ban, I would say. I don't know how that would necessarily work in that case. But the laws that you're talking about don't apply to small rentals, 3 to 4 units where the landlord lives in the building. More so has to deal with fair housing, with rental and housing discrimination, and things of that nature. So I'm not sure those would specifically be covered by anything pertaining to guns.
Okay, well, we're coming close to our time here. I just want to kind of wrap it up, but listening through this last hour and everything, it all seems to come down to really know your landlord, ask your friends, did you rent from blah, 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 and see what they have to say before you sign the lease. And definitely, most definitely, read the whole thing before you sign it. Don't just scan it. It just leaves you open to aggravation in the long run. Trish, do you have anything else to say?
I'm here. No, I'm good. If anyone has any questions, feel free to reach out to me. I'll put my information in the chat.
And Adam, can you put your information in the chat, please?
Yes, I put in the general neighborhood legal services website, as well as our intake line. I just put my email in there as well.
Oh, yes, and ask about your roommate. You know, this is a person that's gonna be right next door to you, you're down the hall, you know, you're gonna be living with them. And it's not just a short period of time, so, you know, see what they're like. Dan, again, please, please, please read all of your lease at least twice. And if you're uncomfortable, go to Trish, or you can come here to OPDC. You can just email it to me. If somebody can put my email in the chat, because I don't have my computer open because we didn't want echo. Email it to me, I'll read it. I do this all the time. Trish does it all the time. We're very happy to help you guys with this stuff. And particularly at this time of year where I know there's a lot of pressure to get things set up for the fall, just shoot an email. It'll take you a minute. And it might save you a lot of aggravation down the road. What? Oh, Devon?
Hey guys, yeah, I saw a question in the chat and I'm not sure if it was addressed, but I'm also curious. So if I did miss it, I'm sorry for repeating this. Is there any kind of way that, you know, going into that situation that you can, is there like any kind of free database or service that allows you to look up past tenancy violations that could be public record or would have been reported to landlords that another tenant could see about someone that they might room with?
Yeah, so this isn't specific to landlord tenant cases, nor does it report anything specifically to landlords, or does it report anything that are violations of your lease. What this is basically a website to check the court docket in Pennsylvania. So this is called the Unified Judicial System Portal. This is what you can use to the I mean, this is what landlords do, right? They check this, and if they find your name on this under a landlord tenant case, then effectively they cross you off the list, right? So this will something will only populate here if you've had a legal action filed against you, not if you've like breached your lease or gotten into a dispute with your landlord that's outside of the legal nature. This is if you've had an actual landlord tenant case against you. I mean, you can look up all kinds of things on here. It's free. It's public interest, or it's public knowledge. It's publicly accessible.
And if anybody needs any help with that, I can do that too.
There used to be a website called landorslum.com where people would rate their landlords and file the complaints, but it's no longer
The
exists.
Justice Initiative has resurfaced again with the new landlord site. I don't know if it's live yet because they did an announcement a couple of weeks back. So I'll have to look and see if it is live at this point, and we'll let you know on that. So I'm going to say thank you, everybody. Does anybody have any last questions, comments, or theories?
I was just wondering, Adam, if you got through your whole list of tips from the beginning of the video, if you had any spare ones that you wanted to throw out.
Yeah, just a couple of things that I could list off quickly. Check for snow removal and things like that. You might actually be liable for that, so just check that. And last thing I had was security deposits. Huge one, super common. Security deposit laws basically are only dealt with after you move out. Once you move out, your landlord has 30 days to either return your full security deposit or to give you an itemized list of what they spent either all or part of your security deposit on. If they don't do that within 30 days, you can take legal recourse against them, but you have to make sure that you provide your landlord with a forwarding address so they know where to send your security deposit, because they can't send it to you if they don't know where you are. If it goes beyond 30 days, you should communicate with your landlord that you want to know about that. And then if not, you can take legal recourse against your landlord for actually more than the amount that your security deposit was. But your landlord effectively has 30 days to deal with all of that once you move out. And that was it.
That was just saying things in the chat. I said that was just saying things.
So we're good?
Yeah.
Okay, I want to thank everybody for coming tonight. Thank you, Adam. Thank you, Trisha. Thank you, Dylan. And we will see you next month. I don't know what next month's Let's Talk is about, but you'll be here. So everybody have a good and safe week.